Good evening. I'm Leonard Baynes, the Dean of the University of Houston Law Center. You are attending a forum on the 2020 presidential transition, which has raised many legal, political, and societal issues. For those who may not know about the University of Houston Law Center, it's a top-tier law school with nationally ranked programs in health law, intellectual property, energy and environmental law, tax law, and the part-time program. And we regularly hold forums on important issues like race and social justice, immigration law, and election law. Let me give you some context before I turn it over to our panel of experts. The 2020 United States presidential election was the 59th quadrennial presidential election held on Tuesday, November 3rd. The Democratic ticket achieved 51.3% of the popular vote, which was the largest percentage of the popular vote won by any challenger to an incumbent president since 1932. The election saw the highest voter turnout since 1900, and in probability, it probably is the largest turnout in all times, because remember in 1900, women and many of people of color were unable to vote. Both the Democrat and Republican tickets received more than 74 million votes, surpassing Barack Obama's record of 69.5 million votes from 2008. The Democratic ticket received more than 81 million votes, the most votes ever cast for a candidate in a US presidential election. The Democratic ticket won 306 electoral college votes, and the Republican ticket 232. At 78 years old, President Biden is the oldest first-term president, the first from the state of Delaware, and only the second Roman Catholic president ever elected, the last being John F. Kennedy in 1960. Vice President Harris is the first woman, first Black, first Asian American vice president, and with her election, the highest ranking woman and Asian American government official in the United States. Because of the record number of ballots voted by mail-in because of the pandemic, some swing states experienced delays in vote counting and reporting. This led to major news outlets like the New York Times, Washington Post, AP, and Fox delaying their projection of Biden and Harris as winners until the morning of November 7th, 3.5 days after the election. Before, during, and after the election, there were allegations made of widespread voter fraud. However, Attorney General William Barr and officials in each of the 50 states found no evidence of widespread fraud or irregularities in the election. Federal agencies overseeing the election security said it was one of the most secure balloting in American history. Scores of legal challenges were made to suppress the counting of votes in major cities in several swing states. Virtually all of the cases were dismissed for lack of evidence of fraud. State election officials were also pressured to find votes, and shadow electors were designated in several swing states. The election results in each state and the District of Columbia were certified on December 9th. The presidential electors formally cast their votes for president and vice president on December 14th. And on January 6th, Congress officially started counting the votes of the Electoral College, and it was interrupted when a violent mob stormed the Capitol building after a Stop the Steal rally in DC. The mob attempted to stop the vote count because they thought the election was stolen. We saw offices of our nation leaders being defiled and some of our nation's heirlooms being ransacked. We also saw Confederate flags prominently and proudly being displayed. We also saw the stark difference between how these protesters were treated as in comparison to protesters over last summer. Members of Congress and the vice president were rushed away to safe locations in the Capitol building. Other members of Congress huddled under their chairs for safety. 5 people died in the melee, including a member of the Capitol Police. and scores of others were injured by the violent mob. Later that day, when the Capitol building was secure, Congress that day and the next day finished the vote count, confirming the election of President Biden and Vice President Harris. Under much armed security, Biden and Harris were inaugurated on January 20th, 2021. On January 13th, 2021, the House of Representatives passed an article of impeachment against the outgoing president by a vote of 232 to 197 for incitement of an insurrection. It was the most bipartisan impeachment vote since 10 Republicans joined the Democrats in the vote. The articles of impeachment were, and it's also the only president who's been impeached twice in one term in his presidency. The articles of impeachment were transmitted to the Senate on January 25th, 2021. The Senate trial is scheduled for February 8th, 2021. And it is and we'll see what will happen. This is also the first time we've had an impeachment trial of a president that will take place after the president's term has expired. So there's lots of issues here, lots of legal issues, social issues, political issues. A panel of experts will each speak for 10 to 12 minutes. I will introduce each panelist just before they speak and briefly describe their focus. After each panelist speaks, we'll have discussion among the panelists before I open the floor up for Q&A from the audience. So let me introduce our first panelist. Dr. Richard Murray will talk about the Electoral College and its history. Dr. Murray has his BA and MA in government from Louisiana State University and a PhD in political science from the University of Minnesota. Dr. Murray has taught at University of Houston since 1966, where he is currently the Bob Lanier Professor of Public Policy in the Department of Political Science and a Senior Research Associate in the Hobby School of Public Affairs. Dr. Murray's academic research interests have focused on Texas and Houston politics and elections, and his current research at the Hobby School centers on how demographic changes in Texas is changing the partisan map of the state as growing metropolitan areas become more diverse while small rural towns, Texas towns, remain more homogeneous. Dr. Murray has testified in voting rights and redistricting cases in Texas and Harris County since 1971. Professor Murray is currently a consultant for the African American members of Congress from Texas and the Texas Black Legislative Caucus. Let's welcome Dr. Richard Murray.
Thank you, Dean. Delighted to be with you folks today. As the Dean mentioned, we've had 59 presidential elections since the Constitution was approved. As expected, in the first one, Washington was the unanimous choice of the new Electoral College, and he was easily reelected 4 years later in 1792. But things began to move in a direction the framers did not anticipate in the third election. By that point, political parties, which most of the framers had a very low opinion of, were increasingly beginning to dominate American elections. And that third election, which the Federalist Party that was emerging rallied behind the Vice President John Adams, and the rival emerging party, the Jeffersonians, Democratic-Republican formal name, but it's called them the Jeffersonians, backed the former Secretary of State, Thomas Jefferson. It was a hard-fought election out in the states, and Adams prevailed and became the second president. But he lacked a lot of political skills. He gets a good history account today, but it was prickly, hard to deal with, not very interested in reaching out to the public, and thus very quickly a strong opposition movement, again led by Jefferson and James Madison, emerged. So at 1800, our fourth election, we saw a transfer of power, and a pretty bitter one, because clearly the Jeffersonians had won a majority out in the American states and were poised to have the first turnover of power. But among the numerous flaws that existed in the Electoral College, not anticipating political parties, was the fact that the electors had two votes. and they didn't distinguish between a vote for president and vice president. To win either position, you had to get a majority, but there was a party line vote in 1800. The Jeffersonians electors all voted for Jefferson and all voted for Burr, probably because of Burr's behind the scenes maneuvering, and you had a tie. Well, then as now, ties don't work in the Electoral College. You have to get a majority in the singular vote that's taken on the same day in all the states. So we had a mess, and we found out that the fallback mechanism the framers had devised, that the election of the president goes into the House of Representatives, but there the vote is by individual state. And again, a majority is required. And that turned out to be a hell of a mess. 35 different times they tried to vote and they either got a tie or nobody got a majority. Finally, Alexander Hamilton, a bitter rival of Jefferson, but convinced that the most dangerous man in America was the other finalist, Aaron Burr, behind the scenes swayed the elector from Delaware, and Jefferson was elected as the third president. But it was a bitter election. Among other things, it gave us the midnight judges, which perhaps some law professors will mention, led to the famous Marbury versus Madison case that was decided by the Supreme Court in 1803. But it was a messy transition, and there were weeks of uncertainty before it was resolved. We found out again in 1824, when by then the dominant party of the Jeffersonians was unraveling and too many people ran for president in the electoral voting around the states. And so nobody got a majority, not a tie. The tie possibility had been substantially removed by the passage of the 12th Amendment, so that after 1804, electors vote for president and vice president distinctly. So that sort of solved the tie problem, but it didn't solve the problem that you still need to get a majority in the Electoral College. And if several people are contending, it's very likely going to fail. And that happened in 1824. So we had another long period where it was quite unclear who would be the president. And this election in the House was messy. At the end of the day, after a lot of behind the scenes bargaining, the candidate that had gotten by then the most popular votes, which started in many states electing electors by direct vote of the white men who could vote, it was Jackson, Andrew Jackson, and he also got the most electoral votes, but not a majority. And he was done in the maneuvering in the House of Representatives, and the election eventually went to John Quincy Adams. We didn't pass a constitutional amendment to deal with this second failure of the Electoral College, but we did see Jackson and his partisans create a new mass political party, the Democrats, that are still around today, to make sure they, across the country, were prepared to contest all the electoral votes and greatly increase the likelihood that the Electoral College would make a decision, which in fact has happened in every election since, although messily in 1876 and in 2000 and in 2020. But this process has mostly worked, in part because 21 times the sitting president has been reelected, so there isn't much transitioning there. 13 times the new president is a member of the sitting president's party, sometimes the vice president, like George H.W. Bush in 1988. So those transitions go pretty easily. But you still got a lot of other cases where things have worked fairly smoothly. And that's, despite all the problems with the structure of the Electoral College, is mostly a result of the emergence of traditions that have been powerful, at least since the 1890s. One of them is that you tally the votes pretty quickly, state by state, and these are added up. And you had the telegraph from the mid-19th century and radio in the 20th century. And so the tallies pretty quickly in most elections reveal who's likely to win weeks later when the formal process ends. So what really improved that process in terms of it working smoothly was the loser conceded. In 1896, William Jennings Bryan, 2 days after the election, a hard-fought election against William McKinley, telegraphed McKinley, congratulated him, wished him the best, and established a terrifically important tradition in American politics that long before the complicated, lengthy, formal process of states certifying their votes, certifying the electors meet in the Capitol and send their votes to, way before that, most of the country thinks they know who the president is because they found out through the national communication networks. So from William Jennings Bryan forward, very often we have this ritual. And after the advent of radio and then television, on election night, we watch the votes be counted. And very frequently, we see the media says, so-and-so has won. And that person then usually quite quickly concedes. And this makes for a far smoother transition than might be the case. Of course, that was really tested in 2000 when you had the problem that in one of the biggest states with 27 electoral votes, the popular vote tally for Florida's 27 votes was so close that you couldn't tell who was going to be awarded. And, most states like Texas and Florida do winner take all. Gore had 267 votes, but he was short of the 270 needed. Bush had 244, I think. So if he got the 27 from Florida, that would put him just over the hump. And we couldn't tell because in an election with 6 million plus voters, and you get down to a difference of less than 1,000, there are always going to be thousands of ballots that it's very difficult to determine. And we had this famous, Bush v. Gore lawsuit that the Bush folks basically out legally maneuvered the Gore people, got the election into the Supreme Court, where finally 5-6 weeks later, the Supreme Court stopped the counting process in Florida, effectively making George W. Bush the president-elect. And Al Gore followed the tradition. He immediately went on television and said, while I bitterly disagree with the decision of the court, I accept it. And he refused to allow Democratic senators to object in the tally in early January when the new Congress had been seated. Ironically, Gore, as the still presiding president of the Senate, was in the chamber and announcing the results, despite the fact that he had won a few more votes in the popular counting than George W. Bush. So that controversial case went fairly smoothly, but it showed, you've got these continuing problems, the wrong winner problem. It's quite possible with these winner-take-all rules that somebody gets more popular votes, but doesn't win in the Electoral College. But that's been contained because, again, the losers have accepted the results. And notably in 2016, to the great surprise of Hillary Clinton and most Democrats and most political scientists, Donald John Trump won over 300 electoral votes, and Hillary Clinton at the end had 227. She had a nearly 3 million vote lead in the popular tally, but it was pretty clear late on the night of November 8th, she had lost the presidency. And she followed the tradition since William Jennings Bryan. She conceded the election to Donald Trump. And the outgoing Obama administration followed the other tradition, one of the other traditions that they graciously tried to assist the transition. But these are all informal arrangements. And when you get someone like Aaron Burr in 1800 or Donald John Trump in 2020 that doesn't accept some of the basic traditions of American democracy, you got a problem. And that's what we saw in the last 2.5 months. Because if this is a rickety process that works in a way it was not designed to work at all, and to a great degree functions only because of kind of the sort of ladies and gentlemen agreement that the loser concedes. But what happens when a loser not only won't concede, but falsely claims that he was cheated of an election that he claims to have won with a landslide? So in 1800, we kind of had an American scoundrel known as Aaron Burr, who was later tried for treason. He was not in office, so this was a separate trial from impeachment. And in 2020, we've had another person that many would consider to be a first-rate scoundrel. And of course, he faces a trial in the Senate in a matter of days. So mostly the system has worked, but it works to a great degree, not because of the formal structure, but because we have evolved a set of important traditions that enable power usually to be handed off even when one party defeats another and there's a change of administration in partisan terms. Thank you.
Thank you, Dr. Murray, for your very concise history of how the Electoral College has worked and not worked. Thank you so much. I'd now like to introduce our second panelist, who is Professor Daniel Morales from the Law Center. He's going to talk about the storming of the Capitol and the siege of the Capitol and the racial implications of that siege. Daniel Morales is the Associate Professor of Law and the George Butler Research Professor who specializes in immigration law. His research addresses the legal problems that arise because immigration law acts on non-citizens, yet is made by and for the citizenry. His scholarship has appeared in top law reviews. Professor Morales joins the Law Center from DePaul University, where he was honored with the College of Excellence in Teaching Award and the Spirit of Inquiry Award for his research excellence. Professor Morales began his academic career as a William H. Hastie Fellow at the University of Wisconsin Law School, and subsequently clerked for the Honorable R. Guy Cole Jr. of the U.S. Court of Appeals for the Sixth Circuit, and the Honorable Joan B. Wachall, U.S. District Court for Northern District of Illinois. He received his JD from Yale Law School and his BA magna cum laude from Williams College, where he was elected Phi Beta Kappa. He has practiced law at Jenner and Block and Kirkland Ellis. He teaches immigration law, immigration, and Latinos in law. Let's welcome Professor Daniel Morales.
Thank you so much, Dean. It's lovely to be here. It's wonderful to be invited, although I find that this is it's emotionally difficult to think that our democracy is where it is right now with the siege on the Capitol. And so I want to kind of reflect on some of the deeper forces that I think have brought us to this moment. I think it's really easy to focus on the Capitol siege or Trump's ban from Twitter or Marjorie Taylor Greene. But I want to try and place what we're seeing now in a sort of longer tradition that is part of an American tradition, unfortunately. And it's the other side of the coin, I think, of what the American project has been over the course of its history. So I want to start out with a concept from Benedict Anderson. Benedict Anderson was a anthropologist at Cornell, I believe. And in 1980 or so, he wrote a book called Imagined Communities. And what Benedict Anderson pointed out that I think is a really important insight is that achieving nation states is actually a huge enterprise of the imagination. In other words, in order for me, to feel empathy and like I have a compatriot in the United States as a citizen, when someone is, say, harmed in a hurricane in Florida, requires to me sitting in Houston or sitting in Chicago, where I used to live, to imagine them as a compatriot. I don't know these people. They're not part of my village. I will never meet these people. So in other words, I think for our purposes, a nation's image of itself is incredibly important to how it functions. And that's all the more true in a democracy where we require a lot of citizens in terms of trust, belief in institutions, and as we're talking about, unfortunately today, belief in the legitimacy of free and fair elections. And so I want to kind of reframe our moment as a shift, kind of the product of a shift in what our imagined community is, right? And so I think first we have to kind of reckon with what kind of imagined community America historically has been. And I don't bring these things up to denigrate, I think, the tremendous achievements of America. I think we have a lot to be grateful for and proud of, and I'm proud to be a citizen myself. But I think any honest appreciation of what America has been has to grapple with sort of the other side of what America is. And, that side is that, to put it sort of frankly, the United States of America has always been imagined as a European white settler colonial enterprise, right? And throughout American history until really quite recently, until I would say 1950, 1960, it has sort of unabashedly been that, right? And so as an immigration scholar, I have to teach my students about immigration history. And so some of you in the audience might not know, but Asian Americans were not able to naturalize after the passage of the avowedly racist Chinese Exclusion Act, which found in the late 19th century that Chinese Americans and more broadly all Asian Americans were, quote, unassimilable, and barred them both from immigration and naturalizing. That work wasn't undone till the mid 1950s. Similarly, the first immigration, the first major law that sought to limit or regulate immigration was expressly an effort to return America to favored white racial stock. So, in other words, the concern in the 20s when the Quota Acts were passed was that Italians, I mean, and literally this is what was said in congressional hearings, Italians have low IQ, and so they shouldn't come to the country because they are going to denigrate sort of the race of America. Same with Greeks and other Southern Europeans. And so what the Quota Acts did was it tied visa entry to the national origin during the founding period, basically. So it was literally an attempt to go back to sort of a white Protestant Northern European social mix, and to restrict entry by what were then referred to as the lesser races of Europe from the South and to the East. Now, of course, today we all think of those folks as white, but that itself, sort of the production of the white race, was something that happened after 1920 and through 1960. And so, so those are just some examples. And of course, African Americans, right? At inception, right? African Americans were viewed as not only unfit for citizenship, but unfit for humanity, right? And so all this is to say that we are in the midst of an incredible transition. And I think a lot of what we're seeing, and I say this, is some fear about that transition, right? And so I don't think we can think about the big lie that Trump told and that Republicans support without thinking about the broader ways in which that image of America as a country run for and by white Americans is under threat to people who don't feel comfortable seeing faces that don't look like the people we're used to seeing in power have that power. So, to fortify this, I want us to think about recent history, right? And in relation to Trump. So, Barack Obama became president, 8 or 9 years, oh my God, 8 years ago, 10 years ago? I don't even know. It feels like another century, in 2008. So in 2008, right? And for a lot of America, that felt really, really good. And I would, venture to say for maybe most of America, because I want to give people the benefit of the doubt here. To see an African-American man take this position of power. Nonetheless, I think especially at this point, it's undeniable that having that sort of image in people's mind nationally as this image of America was deeply distressing. And, a lot of social scientists have quantified this. I love telling my students about this example. One social scientist named Brian Enos did an experiment in Massachusetts, and he put people on the train that spoke Spanish in front of them, right? And so he surveyed sort of the racial attitude of whites before and after that encounter. And whites tend to become more conservative when they're confronted with data about this demographic shift we're undergoing right now. And obviously the linguistic shift is triggering as well. So I don't have too much time. See, I talk too much. So in any case, so we have Barack Obama. How does Trump ascend to power? Let's be clear, Trump started with the lie of birtherism, which got him a lot of traction and attention within the Republican Party and especially in the base. And also, long before Republicans in Congress refused to condemn the big lie, they refused to condemn the lie about birtherism or prevaricated in various ways to sort of manage this line, right? What else did Trump? Trump opened his first tweet was something to the effect that druggies, rapists, and killers from Mexico are coming into the United States. Again, triggering that fear of a multiracial society. And yes, with a valence of illegality and illegitimacy, right? These people don't belong to the image, the imagined community of America. And of course, Trump played this throughout his term, right? And so the rest of it we know, right? The big lie, led, I think, to this siege on the Capitol. And I think the question now for America is, what kind of community do we want to become? I think we have a lot of white Americans and obviously a lot of minority Americans, though not all, that are ready to enter into this brave new world of multiracial political power. I think there is a significant portion of the populace that either consciously or unconsciously feels extremely nervous about that prospect. And I think a lot of what we're seeing today is symptomatic of that deeper anxiety. So I'll end there.
Thank you, Professor Morales. That was a very cogent conversation about race and how it may impact voting in our current circumstances. I'd like now to introduce our next panelist, is Emily Berman. She'll analyze Section 3 of the 14th Amendment and the need for reform of the Electoral College Count Act and the implications for the transition of the increased exercise of executive power in recent administrations. So Emily Berman is an Associate Professor of Law at UH. We actually started at the same time. I started as Dean and she started as an Assistant Professor. She has her BA from Duke University, her JD and LM from New York University. Her scholarship examines unique separation of powers challenges that arise in constitutional, statutory, and regulatory regimes governing national security policy. She focuses on ways to impose traditional conceptions of government oversight, such as checks and balances and democratic accountability on law enforcement and intelligence operations, where such oversight is frequently absent. Prior to joining the University of Houston Law Center faculty in 2014, she taught for 2 years as a visiting assistant professor at Brooklyn Law School. She previously was a Furman Fellow and a Brennan Center Fellow at New York University School of Law, and held positions as counsel and Katz Fellow at the Brennan Center, where she developed policy recommendations, drafted reports, and engaged in advocacy regarding US national security policy and its impact on civil liberties. After graduating from law school, Berman clerked for the Honorable John M. Walker Jr. of the Second Circuit Court of Appeals. Berman's work has been published in many top law reviews. She teaches national security law, foreign affairs law, and constitutional law. Let's welcome Emily Berman. Thank you.
Thank you so much, Dean Baynes, and thanks to all of you for joining us tonight. There's so much to talk about with this transition. I decided to do sort of a little sampler and spend just a few minutes on several different topics. I'll barely scratch the surface on any of them, but I'm happy to discuss any of them in more detail in the Q&A. So the first issue is the Section 3 of the 14th Amendment. So President Trump's impeachment trial is next week, but as impeachment seems sort of increasingly likely to fail, there are those who would like to preclude Donald Trump from running for president in 2024. And if that's not going to come by being disqualified after being convicted at his impeachment, they've raised the possibility of invoking Section 3 of the 14th Amendment. Section 3, here it is, and in relevant part, it says that no person that holds an office under the United States who has taken an oath as an officer of the United States can hold office again if they shall have engaged in insurrection or given aid or comfort to America's enemies. And so some people have pointed to this as an option that might apply to Donald Trump. And I think it raises some interesting questions and some interesting uncertainties. So first of all, it does not define insurrection or giving aid and comfort to America's enemies. So we don't know exactly how that might be defined. It applies to officers of the United States. It's not clear that the president qualifies as an officer of the United States. It doesn't have any clear enforcement mechanism in the amendment itself. So it's unclear, even if Congress voted to say that we believe President Trump falls within the scope of this prohibition, how would that prohibition be enforced? And then finally, there are questions about whether it makes sense to use a provision clearly designed to bar Confederate loyalists from post-Civil War government to apply it to this very different modern circumstance. So that's issue one. Issue two is the Electoral Count Act of 1887. And in some ways, this picks up from where Dr. Murray left off, in the sense that it's an issue of our sort of rickety, outdated system of selecting presidents. Now, the Electoral Count Act sets out the process by which electoral votes are counted. And it was adopted in the wake of the election of 1876, in which Rutherford B. Hayes and Samuel Tilden both claimed victory in 3 southern states. And so those 3 states sent 2 sets of electors to the Congress to count. And the only way that the United States avoided having 2 simultaneous inaugurations of 2 different people was a last-minute compromise that gave the presidency to Hayes, but ushered in really the era of Jim Crow by ending Reconstruction. And so while the act is an improvement on that scenario, that it was put in place to prevent from happening again, it's got a multiplicity of flaws. And so just to show a couple examples, so when counting the electoral votes, which the process that played out on January 6th of this year, Congress has the power to reject votes that are, quote, not regularly given if both houses agree that in fact they were not regularly given. It doesn't define what that means. So imagine this year there had been a Republican majority in both houses rather than just one. I personally am not confident that they wouldn't have thrown out the votes from Pennsylvania, Georgia, Arizona, and alleged that they were, quote, not regularly given. Similarly, if we see a scenario like the Hayes-Tilden situation where states submit 2 different slates of electors, say one from a Republican legislature, one from a Democratic governor, or vice versa. If one party controls both houses, they can choose which of those 2 slates of electors are going to be counted. If the houses don't agree, then it seems that the electors provided by the governor of the state would take precedence, but even there, the act's not particularly clear. So these are just a couple of sort of nightmare scenarios that could play out under this law and could allow the extreme partisanship that we're experiencing really interfere with the American people's selection of the president. I think we dodged a bullet this time in that the election results were relatively clear. We had honorable public servants at the state and local level who upheld them. But next time we might not be so lucky. So I think we need to take a hard look at this statute and adopt a much clearer, narrower set of rules about when the votes that come from the states can be challenged and on what basis and what the process for doing that will be. So finally, I want to say a word about a trend that I am calling policy whiplash, which is not unique to this transition, but I think it has surfaced in some particularly problematic ways this time. So increased polarization in our politics in recent decades has led to presidential administrations increasingly relying on unilateral executive action. So, for example, President Obama, the DREAM Act fails in Congress, and then he implements DACA as an executive branch policy. He knows that he's not going to be able to get agreement from 2/3 of the Senate to turn the Paris Climate Agreement or the Iran nuclear deal into treaties. So he simply signs them as presidential agreements. President Trump did much the same in several areas. Congress didn't want to fund his border wall. He declares an emergency and builds it anyway. And of course, multiple major changes in immigration policy that came directly from the White House. Now, the thing about unilateral executive action is that what one executive gives, the other can take away, right? And that's where the whiplash comes in, because Obama signed these two agreements, Trump comes into office, promptly withdraws from both of them. Also tried, albeit unsuccessfully, to discontinue DACA. Similarly, Joe Biden, he's issued 28 executive orders in his first 2 weeks, rejoining the Paris Climate Agreement once again, rejoining the World Health Organization that Trump had withdrawn from, modifying multiple immigration policies. And so because this is what happens more and more frequently as we rely more and more on executive power to make policy, outgoing administrations are starting to try to find ways to embed their preferences in ways that the incoming administration can't easily undo. And so there are a few consequences that I have seen just in the past several weeks. So there's a phenomenon called burrowing, which usually refers to political personnel being put into the civil service so that you have political appointees now in the career offices rather than in political appointee offices. And I've seen this with both people and policies as well. So just a couple examples. A former staffer of Republican House member Devin Nunes was installed as general counsel of the National Security Agency, a job for which he is not qualified. The day before President Biden's inauguration, the acting head of DHS entered into an agreement with the union representing ICE agents that gives that union veto power over any policy change in ICE that affects agents. So essentially gives ICE veto power over changing immigration policies. There are also significant foreign policy implications. Whether you're talking about our allies or our adversaries, it's really difficult to generate and maintain relationships if the countries don't know from one presidential term to the next where the United States is going to be. And because agreements, we sign on to agreements, we withdraw, we sign on again, there's no consistency there. Nobody knows whether they can count on us, whether our agreement actually means anything. And then finally, I think if new administrations come in and quickly change the litigation positions in the executive branch, which is another thing that we're seeing a lot of, I think that erodes the credibility of Justice Department and government lawyers generally in front of the courts, who really rely on them to be sort of straight shooters when it comes to the law. So You may have whiplash from that presentation. I know I covered a lot in a brief period, but this transition has just given us all so much to think about. I wanted to sort of put a bunch of things on the table for discussion, and I look forward to Q&A.
Thank you, Professor Berman, for providing us with a tasting menu of a variety of different topics. Thank you so much. Now it's my pleasure to introduce our next panelist, Seth J. Chandler, Professor Chandler, who will analyze the election law cases, the Bukvar case, as well as election security. So Seth Chandler is the Law Foundation Professor of Law at UH Law Center. He specializes in insurance law and the application of mathematics and computer science to law. Professor Chandler won the prestigious university-wide Teaching Excellence Award, was the first year winner of the Innovator Award from Wolfram Research, received the President's Medal from Loyola University for his extraordinary service in the aftermath of Hurricane Katrina, and has been called on twice to testify before Congress on the Affordable Care Act. He founded two blogs, ACADeathPlusSpiral.org, which address the ACA, and catrisk.net, which address catastrophic insurance in Texas. Professor Chandler's blog entries have over 400,000 views. He has his undergraduate degree from Princeton, his law degree from Harvard Law School. He practiced at Munger, Tolles and Olson, Los Angeles, and Williams and Connolly, and Washington, D.C. before beginning his academic career in 1990 at UH Law Center. Professor Chandler teaches contracts, health law, analytical methods, and constitutional law. Let's welcome Professor Seth Chandler. Thank you.
Well, thank you very much, Dean, for inclusion on this panel. I want to talk, first of all, I want to share my screen. That's what I want to do. So there we go. All right. So I want to talk about a couple of areas in which action is needed. I do want to say I agree with everything Professor Berman said. You should pay careful attention to that. One is to talk about electoral college reform. People talk about massive reform, getting rid of the electoral college, basically not going to happen because it needs a constitutional amendment that will never get passed. However, there are things that can be done that do not require a constitutional amendment, and I'd like to talk about those. And I think, I do a lot of work computer programming, and we need to be very concerned about remaining bugs. There was a bug that Dr. Murray noted, but remaining bugs in the 12th Amendment, which is voting by states if there's no majority in the electoral college, which I think could happen in 2024 if the parties fracture, which is not impossible. And we also need to be looking very hard at Section 3 of the 20th Amendment as to what happens when you can't actually conclude a presidential election. We also need to be looking very hard at election security reform. I think we have a false sense of security right now. It's like the Capitol Police, where they thought that everything was going to work out fine, but they really never stress tested their system against a massive attack. And I think we ought to be fearful that people who believe, wrongfully, that they were victimized by election fraud may well attempt to retaliate in kind and exploit the bugs in both the existing law and technology that exists. Why is a constitutional amendment impossible? Because it takes 38 states, and there are at least 12 states who would lose 2 votes effectively were the electoral college to be abolished, and other states would lose 1 vote, and I just do not see the requisite number of states signing up to diminish their power. Some states, I think we need to be concerned, may attempt to diminish popular franchise because the Constitution does not require direct democracy when it comes to presidential elections. I wonder if this isn't going to happen more if the For the People Act, which is H.R. 1 in the current Senate, gets passed, which I think is a distinct possibility. That's going to make some pretty massive changes in the way we do elections in the United States, including getting rid of gerrymandering through requiring independent commissions to do congressional districting. It also does require some additional election security procedures. I don't think the Republicans are going to just sit for this, and I think there will likely be massive litigation about whether this intrudes on the state's role in selecting a president. I do think we need to be very concerned about election fraud in 2022 and 2024. Whether the guy in the horns is right or wrong, you're not going to change his mind. And I think, we've seen concerted action facilitated by the internet, and I can imagine Reddit stop the steal, coming up with coordinated ways to attack our voting system. And as I said, I worry it's like the Capitol Police, who thought they were prepared to deal with the usual uncoordinated small-scale levels of violence, but turned out to really be unprepared to deal with a coordinated mass attack of the kind that the internet facilitates. So in my humble opinion, Democrats should not be resisting efforts at election security in the fear that they're doing so means that they agree there was any sort of fraud. Be very careful that people do not attempt to massively defraud the system in 2024. I want to talk about BookVar, we have Article Section 2, which states, each state shall appoint in such manner as the legislature thereof may direct a number of electors. And I want to note that it's not like Article 1, Section 4 of the Constitution regarding congressional elections. That says that Congress can regulate the time, places, and manner of congressional elections. There is no parallel provision with respect to presidential elections. The other thing we have is we have state legislatures over the past century or two delegating significant power over the details of elections to their executive branch, and those rules have been policed by the judiciary. The BookVar case, currently pending in the Supreme Court, basically challenges that practice of delegation to the executive branch coupled with judicial review. I think because Trump has a really lousy record in the courts and because most of his lawyers are appallingly bad, it's easy for liberals to dismiss that case out of hand. I will tell you, this case is filed by real lawyers, and you have at least 4 votes who thought this was worth hearing. And I think it is foolish to think that it's foolish just to dismiss this case out of hand. The Supreme Court delayed consideration of the case until after the election was resolved, but in some sense that makes it easier for them to decide the case in favor of the Republican Party because it doesn't have any immediate consequences. And I wonder if there aren't 5 among those 6 people who are willing to say that that Pennsylvania really did something wrong. For those of you who don't remember, Pennsylvania, the Supreme Court basically decided that it would accept votes that were received after the election within 3 days, and that would be true even if there were no postmark. So that theoretically, someone who voted a day late and somehow evaded getting a postmark on their ballot, if it got in within 3 days, it would count. Now, who knows how, it doesn't seem to have been a lot of people in that category, but that's what makes this case, and I think in some ways good for the Republican Party, is that it's now an abstract dispute. They have support for this proposition that state courts should not be getting involved in presidential election disputes from a concurrence by Justices Rehnquist, Scalia, and Thomas in Bush versus Gore. And so I think it is not impossible that there will be at least 5 votes to say that there are going to be bounds on what state courts can do in reviewing presidential election policies. Could this case be found moot? You bet. Is it capable of repetition but evading review? Well, I hope we're not dealing with a pandemic in 2024, but we'll see whether that stands up. What I do think is a headline like this would not surprise me, and I can just see the Trump tweet or whatever platform he's on at that time now, which I've tried to predict what the tweet will be. So I will stop there and look forward to taking questions in the Q&A. If I can.
Thank you, Professor Chandler. Appreciate it. Really good information. about those cases, Bukvar especially. Very, very interesting and challenging. We'd like to talk about it more in the Q&A. Last panelist I'd like to introduce is Professor David Dow, who will discuss impeachment and the Senate trial of a former president, pardons, including possibly secret pardons, and possible post-presidency criminal prosecution. Professor Dow is a Cullen Professor of Law. He joined the University of Houston Law Center faculty in 1988. He graduated with a BA in history from Rice University and earned his MA in history, his law degree from Yale University. Upon graduation, he clerked for the Honorable Carolyn Deneen King, judge on the United States Court of Appeals for the Fifth Circuit. Professor Dow is also founder of the Texas Innocence Network, often working with UH law students. He has represented more than 100 death row inmates in the state and federal appeals. His areas of expertise include contracts, constitutional law and theory, and the death penalty law. He has written extensively on these subjects, as well as on equal protection, law and literature, and federal jurisdiction. And Professor Dow has also published several books on the death penalty. He teaches constitutional law, contracts, the Innocence Project, and the Supreme Court term. Let's welcome Professor David Dow.
Thank you, Dean Baynes, and thank you to all of the people who have joined us today. And I'd also like to thank all of my colleagues who have spoken so far. I've learned something from each one of them. I'm going to spend my time, I think, principally focused on the question that the Senate called into stark relief when it took what was essentially a procedural vote last week. And that will, I think, be a central question that emerges at the Senate trial when the Senate trial begins. And that question is whether the Senate actually has the power to try Donald Trump, who is no longer the president. And if we start with the language of the impeachment power itself, it doesn't really tell us very much. It tells us that the Senate has the sole power of impeachment and that punishment shall extend no further than to removal from office, and importantly, barring somebody from future office. In order to convict somebody in the Senate, a vote of 2/3 of the Senate is required, which translates into 67 senators. And with a 50-50 split in the Senate, that means there have to be 17 Republicans who agree to convict Mr. Trump, assuming that all 50 Democrats also agree to do so. If he were to be convicted, then the only vote that is required in order to assess punishment, and in this case, because Trump is no longer in office, the removal provision is irrelevant. The vote that would be required in order to bar Trump from future office would be simply a majority vote. And I think that it's reasonable to assume that if there were 2/3 to convict, there would be a majority to prohibit him from holding future federal office. But I think that it's quite unlikely that there will be 17 Republican senators who agree that the conduct is conduct that can support a conviction, not because they think the conduct is necessarily not an impeachable offense, but simply because they take the view that because Trump is no longer a president, it is therefore beyond the power of the Senate to hold the impeachment trial. And so that is really the issue I would like to spend my few minutes focused on today. And the question is it possible for the Senate to hold a trial for a former president, a president who has lost re-election and is therefore no longer the current president? And the answer to that question, of course, is nobody knows. And the reason that nobody knows is because this question has never arisen before. And unlike mathematics that has answers to problems, even if nobody has figured out what those answers are, law tends not really to have answers until somebody figures out what the answer is, and people don't figure out what the answer is until the problem presents itself. And so I would just like to talk very briefly about a few episodes in constitutional history that I think are germane to answering the question of whether the Senate has the power to try Trump. And there are several instances. Many people who argue that the Senate does have the power point to the Senate's trial of the Secretary of War, William Belknap, who resigned as the Secretary of War in 1876, which incidentally was also the famous disputed election of 1876. And the Secretary of War resigned before the House of Representatives could even impeach him. And so he resigned fearing that he was going to be impeached. Following his resignation, the House went ahead and impeached him anyway. And then the Senate conducted a trial, but the Senate did not convict him. There was a majority to convict, but not a 2/3 vote to convict. Many of the senators who argued against conviction at the trial of Secretary Belknap argued against conviction on the basis that he was no longer in office. And they didn't argue that they lacked the power to convict him, but they simply argued that there was no point to convicting him because he wasn't in office. So if we're looking for a precedent of the Senate having tried an executive officer who resigned prior to facing impeachment, the precedent is that the Senate can conduct the trial because it happened once before. On the other hand, President Nixon resigned, and following President Nixon's resignation, the Senate did not conduct a trial, did not conduct trial on the articles of impeachment that actually never left the House of Representatives because Nixon resigned before they could be voted on and walked over to the Senate. So we have these two examples, and in one instance, the Senate acted, and in that the House and Senate acted, and in the other instance, the House and Senate did not. I think that probably translates into a tie. So what is the likely result? I think in order to figure out the likely result, we need to ask what has been the attitude of the courts towards this type of scenario. And by this type of scenario, what I really mean to be asking is what has been the attitude of the courts toward the power of the Senate to decide how much power the Senate has. And to answer that question, we actually have a couple of contemporary cases, or at least one contemporary case, but it involves two different officials. There were two federal judges who were impeached. One was called Walter Nixon, and one was called Alcee Hastings, and they were both impeached for taking bribes. Walter Nixon was actually convicted in a federal trial. Alcee Hastings was acquitted in his federal trial, notwithstanding the fact that Walter Nixon, the judge, was convicted. The House still moved forward with articles of impeachment against him, and then that impeachment went to the Senate. The Senate has a Rule 11, and Rule 11 of the United States Senate permits the evidence in an impeachment trial to be heard by a committee. And the committee then reports on the findings of fact to the Senate as a whole. And so the evidence that was presented in Walter Nixon's impeachment trial was presented to a committee. The committee voted unanimously to recommend that he be convicted, and recommended to the full Senate that he be convicted. And the evidence was summarized and presented to the full Senate, and Walter Nixon was convicted and removed from his judicial sinecure, which a felony conviction does not have the consequence of doing. Walter Nixon then went to the Supreme Court and he said, the Senate has the power to try impeachments, but what they did to me wasn't a trial because it was only the committee under Rule 11 that heard all of the evidence in my case. And the Supreme Court unanimously held that Walter Nixon lost, that what the Senate did was perfectly fine. Justice White wrote a concurring opinion that was joined by Justice Blackmun, and Justice White said that he thinks that the issue is justiciable, meaning that it is subject to judicial resolution but that he found the procedure employed by the Senate to satisfy the definition of trial. The more interesting opinion is the opinion by Chief Justice Rehnquist, as well as concurring opinions by Justice Stevens and Justice Souter. And all of those opinions suggest that the question of an impeachment trial is a political question. And political question is, certainly all of the lawyers in the audience will know, and perhaps many of the others will know as well. A political question means that it is a question that somebody besides the judicial branch gets to decide. Most questions in the United States we're accustomed to litigating and having some court give us the final answer. But if a question is a political question, it means somebody else gets to decide it, and that somebody else is either going to be Congress or the president. And what the Supreme Court of the United States held in the Walter Nixon case is that the question of whether a trial is permissible is a political question. Now, to be sure, in the Nixon case, they were focused on the mechanical procedures that were associated with that trial. But I think that the language in the Chief Justice's opinion, as well as the concurring opinions, suggests that the Senate has very, very broad power to decide not only what the procedures are going to be, but indeed whether it's going to go forward. And so I think that the question of whether the Senate has the power to try a former president is a question that the Senate gets to decide. And the Senate decided that question 2 weeks ago when 55 senators held or voted that they do have the authority to go forward with the trial. And so there's going to be a trial. And if I'm right, that a court will review that question and find that that question presents a political question, then the Senate determination will be the end of the matter. And with that, I will pause my remarks, and my colleagues and I look forward to answering your questions.
Still on mute. Thank you, Professor Dow, and thank all our panelists. Why don't the panelists come back, turn your videos on, and we'll have just a short roundtable conversation with 2 questions from me, and then we'll open it up to the audience. So one thing for me with all of this is that I wonder about is with impeachment. Let's talk about impeachment first. Can there ever be an impeachment of a president? So we now have, the Justice Department says the president has immunity, basically, in essence, while he's president, right? And, in the last impeachment of this particular president, there were arguments made that, well, we shouldn't impeach him because we have an election and the voters should decide. And now we have, this impeachment where, the House voted while he was president, but then because of delay in the Senate, no trial could happen for, 2 weeks. And so it does seem as though, putting this president aside, that there's certainly a discouragement for impeachment, and maybe that's rightfully so when you need 2/3 to convict. But, what happens if you have a really, really bad president? What do you do as a, electorate or, as a Congress? What do you do? I mean, are we, is the, the politicization of all this, is this causing us to have to bear with presidents that, in essence, might not be the presidents that should be presidents at the time? Just open mic. So is impeachment?
Yes.
Is impeachment really an avenue for removing a president, or is it just words in the Constitution that they put there that really doesn't do very much? I guess let's say that.
I mean, given the political situation, it's always going to depend on the makeup of the House and the Senate, I would imagine. I mean, maybe there is something that President Trump could have done that would have pushed the Republicans over the edge and made them willing to vote for impeachment for him. But for the life of me, I can't think what it would be if the things that he did weren't sufficient. So either it's entirely reliant on the partisan makeup of the Congress, or there's some line that we have not yet reached beyond which even partisans won't go.
I guess I would agree with Professor Berman that it's going to be very difficult in today's environment. And one of the reasons it's difficult in this instance is that President Trump was a master of speaking in code. Like, many criminals who know that they're being bugged. He's very careful, but one can imagine, supposing his comments had gone further and said not that Mike Pence had failed to show courage, but that they should hang Mike Pence, as some of the protesters wanted to do. Or imagine that President Trump hadn't called for a peaceful walk down Pennsylvania Avenue and said, we're going to go to the Capitol. He said, we're going to go storm the Capitol. Now, it might be you still wouldn't have 67 votes to impeach because you couldn't establish causation because of previous commitments to storm. But nonetheless, I think there are President Trump, both in his Ukrainian phone call and in his post-election conduct, was a master of going right to the line and letting other people figure out what he actually, to do the decoding for him.
I would just add two points, and maybe it's just one point to what Professors Berman and Chandler have said, and I agree with them entirely. And those 2 points are that all of the political problems that then become translated into the observation that you made, Dean, which is the increasing difficulty of impeaching in the House and trying in the Senate, are traceable to really two features of the American political system, both of which Professor Chandler talked about. One is that legislative districts are more gerrymandered than they ever have been in U.S. political history, and that's because it was not possible to gerrymander with the skill that members of state legislatures are now able to use, given the collection of data and given computers. And so it was inconceivable that you could have this type of meticulous gerrymandering certainly 2 generations ago and probably 1 generation ago, and that has created real problems in the House. And then similarly, and the other problem that Professor Chandler mentioned is the Senate and Article 5 in the Constitution that provides the amendment mechanism says that 2 things can't be amended. One is that the United States couldn't interfere with the slave trade. It wasn't called that. It was called the importation of persons, but it was the slave trade prior to the year 1808. And the second is equal representation in the Senate. And even if one takes the view, as I do, that it's incoherent to have a constitutional provision that is itself unamendable, as Professor Chandler was pointing out, you need 3/4 of the states to ratify an amendment. And so that means that you would have to be able to conjure up a solution to the equal representation in the Senate provision that appealed to 38 of the states. I think that there are such possibilities. I've been working for the last year or so on trying to come up with some myself, but it is nevertheless a very steep and slippery uphill walk. And the combination of those 2 factors, I think, makes impeachment obviously not legally impossible, but politically challenging.
I'd like to wade in. I've really enjoyed hearing my distinguished law colleagues talk about ins and outs, but back to this point that Professor Dow is making, that the courts have often said it's a political question. And I think that's substantially where we're going to go post 2021. Trump's power comes from something that Machiavelli just dissected 500 years ago: fear, not love, not any kind of statutory power, but in the modern Republican Party, people greatly fear him, and they will continue to do so until the political process shows that that is not a path forward for their own success. Joseph Schlesinger, the political scientist, not the historian, talks about ambition theory. And I think we saw today Kevin McCarthy, a perfect example. He's the House Minority Leader, desirous of becoming Majority Leader in the future. He's got these 2 women, Liz Cheney, daughter of the former Vice President, a stalwart member of the Republican establishment, and Congresswoman Green, Hugh. his conduct is largely explained by what he sees as his political future. Mitch McConnell's in a little different position. Senators have to run at large in states, so their electorates are more diverse. He's a 6-year senator again after being reelected. But if really, it's mostly going to be up to voters, I think, to decide where we go in terms of dealing with this, what to me was outrageous conduct by the chief executive. It went beyond a level we've ever seen in the history of our 44, 45 presidents. And that we'll start seeing in 2022 at the polls. Yes, there are court issues like the Pennsylvania case that are important, but it seems to me the fundamental direction of the republic is going to depend upon voter decisions. That the courts, aren't in a situation where there are no clear guideposts, and where a lot of the actual transition of presidential elections has been by custom, not by law. And restoring those customs is going to require that voters punish Donald John Trump or those who stick with him in the midterm and the next presidential election.
Mr. Morales, do you want to have a word before we open up to the audience?
Yeah, I mean, I can, I think everything that's been said has been really insightful. I guess my answer would be, I think, given the current conditions, and I think given the trends in partisanship, and given this, not only the fact that, of course, the Senate's always been an unrepresentative body, but the difference is the concentration of people in urban areas has radically altered how bad that difference is. And so, the fact that the Senate represents 40 million, that the Democrats in the Senate represent 40 million. I mean, 40 million is 4 Switzerlands. I mean, that is a lot of people. I think tells you, no, I don't see how any now I think a Democrat could get impeached, but I don't see, given the advantages the Republican Party enjoys in the Senate, how any Republican president would get impeached after the failure to impeach the actions of Donald Trump. But maybe that's overly pessimistic.
Okay, so a couple of questions from the audience. So one is, there's a question about due process, because Senator Leahy, who's the senator from Vermont, I guess he's Senator Pro Tem, he's going to be presiding over the impeachment trial because Chief Justice Roberts is not. And the question is, given the fact that he has indicated is likely to vote to convict, is there a due process issue for former President Trump?
No, there isn't. The manner of holding the trial is going to be a political question. The presiding officer in an impeachment trial does not remotely occupy a role that is equivalent to the role that a judge in a trial occupies. And in fact, I think we saw that with the last impeachment trial. We had the Chief Justice of the United States, and he was basically just a figurehead who stood up at the front of the Senate chamber every day and recognized people to speak. So I think both because the role of the presiding officer is really quite different from the role of a presiding judge in a trial, and the fact that the Senate can decide its own procedures, there won't be any plausible, that's not to say that Trump's lawyers won't raise such an issue, but there won't be any plausible due process challenge.
And
I also think that sorry, Dean.
Yeah, well, go ahead, and I'll follow up.
I was just going to say, I also think that just the nature of an impeachment trial, especially this impeachment trial, where you essentially have the witnesses and victims are the jury. I don't see how you can pretend that we should be sort of pursuing the same kind of procedural ideals that we have in criminal trials. It's just not the nature of this proceeding.
Any thoughts on why Chief Justice Roberts is not presiding?
He doesn't. Well, he's not presiding because he only presides when the trial is of the president.
Mhm.
and it's not a trial of a president, it's a trial of a former president. So just under the language of the constitutional text, that's why he's not presiding.
Any
Well,
other thoughts?
I think that's why he's saying he's not presiding. I think, like, let's be clear. The reason he doesn't want to touch it, I mean, for the same reason, he's very solicitous of the reputation of the court. This is going to be one of the most controversial, trials of any president, and he doesn't want a part of it. He doesn't want the taint of it. That's my view, my realpolitik view. But that's
The next question. This goes again about impeachment. Should we, as a people represented by senators, suppose to expect our senators to vote in impeachment trial based on the constituents' opinions on the matter, or as members of the federal government, should those senators vote based on the objective standard of legal, illegal, right, or wrong?
Well, that's not a new question. Edmund Burke, 240 years ago, in his speech to the Bristol electors, made the point that as a responsible public servant, he would listen to his constituents and weigh their opinions, but at the end of the day, he felt that he was bound as a public servant to do for the good of the nation and the larger public. He was, of course, defeated, so that's an object lesson in and of itself, but there's never been a resolution. Most people, however, pay attention to their constituents when they think their constituents might end their political career. And then they're quite sensitive to their constituents. Other times, not so much.
Although there certainly is a lot of conversation about what standards, is this a criminal, should be, the Constitution says bribery, treason, high crimes, and misdemeanors. And so the question, a lot of is conflated to criminal law. Is that, as indicated, seems to be a lot of a political connection to this, or should we really be looking at those particular standards in the constitutions that they're described? What does high crime and misdemeanors mean, actually, I guess, is the question.
I mean, I guess I would encourage us to think about the question more structurally, right? I mean, we can get into the weeds, as a number of my wonderful co-panelists said, there's not an answer to this question, right? As Professor Dow, I think, put very clearly and succinctly and well. And so when there's not answers to questions, I think then we can go back to structure and say, well, I mean, the founders were clearly afraid of demagogues, which I think by any reasonable standard, the tactics that have been used by the former president meet. And so, and they understood the need for accountability. And so, I would suggest that if what happened was not a high crime and misdemeanor, I think that's a major structural error. And I think we have, it's sort of an impossible problem for a democracy if you can't hold people accountable for those sorts of actions. I think we're going to see further democratic backsliding, as many political scientists have pointed out.
I mean, it is interesting that we've had 4 impeachments or about, I guess, including this one, and 3 of them have occurred in the last 50 or so years. Is there anything about that seems to be significant, do you think?
It's 4, not 3.
Did I say 4?
Well,
including,
Clinton,
I guess Trump is
2 for Trump, and 1 for Nixon.
Clinton and Nixon.
Yeah.
Yes.
Well, except there wasn't Nixon, so I mean, there would have been if he had stuck around.
The committee voted, I think.
The committee voted.
Well, the House voted to
no, the House did not vote.
No, he resigned. He resigned before the full House voted.
Yeah.
The committee voted. The committee returned either 2 or 3 articles of impeachment. I can't remember, and then he resigned.
So is there anything that is telling about this era that we've had so many, however many we count, and whatever we count, that we've had so many in this short period of time? Does that say anything about our era?
We're in an era of political hardball where norms have been eviscerated. And, Professor Murray, I think brilliantly pointed out the way that we've always relied on norms. I mean, I think this is what the law doesn't solve all your problems. And the kind of stuff we do in law school, parsing all these legal statutes, like we shouldn't have to do, because all of this should run on comedy and kind of a shared conviction that our democracy needs to survive. And what I think we're seeing is increasing what scholars have been calling constitutional hardball, where every question that used to be resolved without recourse to kind of the persnickety legal arguments that we do in law schools and courts are now either being litigated or literally, or they're being litigated by the actors, by political actors in political institutions. And so I think that's what we're seeing, is perhaps the impeachment cycle is a kind of constitutional hardball.
Any other thoughts? So if not, let's move on to a few other questions. So there's a question specifically for Professor Chandler about the electoral college compact, and what do you think about that?
Right. So what I think about that is that I skipped a slide in my presentation. Now I'm just thrilled that I can bring back.
Oh,
So
okay.
there are two reforms of the electoral college that we ought to be thinking about. One is very doable if the states would just do it, which is to use the Nebraska or Maine system, which is not winner take all. And if a lot of states would go to that, it would solve a lot of the issues with the electoral college. Not all of them, but it would mean, for example, that you wouldn't necessarily have whatever it was, 20x votes dependent on the outcome of Florida or Pennsylvania. You might have 1 or 2 votes in a couple of districts that would depend on the outcome. Or maybe there's a threshold, you get a few more electoral votes when you go from 40% to 45%. But that is something that states could do. In fact, back at the very beginning of the Republic, we did not have winner-take-all systems, although George Washington won it all anyway. So, but actually non-winner-take-all systems persisted in a few states up until 1820 or so, and then we kind of moved away from it, except for a few outliers like Nebraska and Maine. The other option that the questioner posed is something called the National Popular Vote Interstate Compact, which has been around since 2006. And it basically says, we agree that we will cast our electoral votes for the winner of the popular vote, but only if 200 states that have 270 electoral votes between them agree to do so as well. And right now we're at 196. I have doubts for the reasons, that I identified earlier, that we're going to get to 270. It's going to require a lot of sweetening. And also we're going to need congressional assent under Article 1, Section 10. Compacts have to be approved. I have my doubts whether that's going to get through the Senate. The other issue, and this is true of other methods to increase the popular vote, is it creates incentives in the states that want to aggrandize their power to enlarge their franchise so that they have more people who count. Like, California could decide that 16-year-olds could vote, and then Utah could retaliate by letting 15-year-olds vote or felons voting. And so there are a lot of issues that are created by placing more emphasis on a popular vote. But there is this possibility that avoids the need for a constitutional amendment. And I got my slide in. I'm so excited.
I think the challenge, though, Professor Chandler, would be that if you went through congressional districts, they are very gerrymandered. And, so you could do that, and it certainly may avoid some of the issues you raised. But do you think that that would be, a concern that the districts are so gerrymandered?
Right. It's not perfect. The other way you could go, though, would be basically to have a function that gave you a certain fraction of the electoral votes, depending on the fraction of the popular vote that you got. So that if your state, went 45% for Biden and you had 7 electoral votes, well, maybe at least you got 3 that got to be cast for Biden. And so basically the electoral college would be serving as kind of a rough proxy for the popular vote, but a state wouldn't be able to increase its power by letting more people vote. And so in my humble opinion, that actually is a pretty good solution to the issue, but the fact that I like it does not mean that it will pass.
As a political scientist, I'm afraid I like to see it generally, but that only works if the big states pitch in. If everybody else split their vote up, California would elect the president in almost every election if they voted all 55 of their votes for one person.
Right,
Texas would have cast, we had 38 votes, so we split 58, 52%. So Trump would have gotten probably 21 votes in Texas and Biden 17. Hell, we'd be less important than New Mexico because we'd have a net of 4, and New Mexico wades in with 2 million people and 5 electoral votes, all for Biden. So New Mexico outvotes Texas. Politicians are a little slow sometimes, but they're pretty, they can count up to.
Right. No, this is probably what they figured out back in 1824 when they moved away from the system, except Nebraska and Maine didn't get the memo. But it sure would be nice if we could move to a more proportional system.
You can see once some state adopts winner take all, particularly a state of some size, not like Maine or Nebraska, it puts an enormous pressure on every other big state because they're giving the large states with substantial numbers of electors a huge amount of power. And one final comment I'd like to make today. We talked a little bit peripherally about gerrymandering. I've been working on redistricting since I was a PUP professor in 1971. There's something afoot now in the country. The demographic changes that were referenced by other folks, the population growth, we'll see that in Texas. We've added 4 million people here since 2010. Virtually all of them are persons of color. So I think conservatives, in some sense, are a little bit like the old Southern conservatives of the 1840s and 50s that saw what was about to happen in the House of Representatives. They were going to be hugely outnumbered in the House. The Senate's going to stay what it is, which is a big problem for progressives. But the House is about to change, in my view, because so much of the population growth is in the metropolitan areas. Look at those 2 congressional seats in Atlanta that were very safely Republican until they elected Democrats. Generally, demographic change doesn't reverse. In Texas, you have very clever map drawers on the Republican side. They did a marvelous job in 2011, but they really have a tough task in front of them in 2021. Too damn many people aren't voting the way they used to, and too many new people. That's how John Culberson, an 18-year incumbent, suddenly gets unhorsed. And the 32nd district in Dallas, it was one of the safest congressional districts in the state. All of a sudden, no, a black guy that played in the NFL and got a law degree afterwards suddenly becomes the new congressman. So the Senate is what it is, and that's not going to change. But the House is on the threshold, as I think conservative theorists realize, it's going to be very unfriendly going deep into the 2030s and 40s because the rural areas that are the base of the Republican districts, they ain't going to have many members, folks. Louis Gourmet needs more people. The only place in Texas to find them is in the triangle between Dallas, Fort Worth, Houston, and Austin, San Antonio. So you can gerrymander, but as with the explosive growth of the North versus the slow growth of the South, that conservatives correctly realized impending disaster, and therefore refused to cooperate in 1860 in a transfer of power. The House is in play going forward in a very different way.
I think the other consequence that's going to come from that is we're going to see a lot of restrictive voting rights, a lot of effort to make it more difficult. One thing about Professor Chandler, when you're talking about your plan that would encourage people to have more people vote, I thought, well, yes, let's do that, because I think right now the move is going to be quite strongly in the opposite direction as a means of trying to delay the moment of reckoning that Dr. Murray is talking about, which I think is inevitable, but if we're still a democracy by then.
I'm encouraged by what Stacey Abrams did in Georgia. She said, okay, I got screwed. Let's go out and register even more people and vote. And they had a pretty good election 2 years after she thinks she was.
I think the difficulty, though, is, I mean, what I don't disagree empirically with what Dr. Murray said at all. I think he's absolutely right. But I think what we're seeing is loss of faith in democracy, because our system has always been bad at delivering goods to voters that they vote for because of bicameralism, right? I mean, structurally, parliamentary systems are much more stable. They're much better at tying promises made to voters to actual achievements. But we do seem to be in a vetocracy, which the conservative professor Francis Fukuyama has written about at length. And I think that's part of the story too here. I mean, I know I talked a lot about race, but it's also true that the same period where all this diversifying was happening was also a period of radical economic change, was also a period of democratic sclerosis. And so, I hear that there's going to be more gridlock, and I sort of am in Professor Berman's camp, that I'm like, if we're still a democracy, because I don't know how much more failure to problem solve the electorate can really take.
Well, that's just a sad note, but understandable. I mean, I think, but what I think all of you are pointing out is sort of two theories of what the Democrats, should do. One is, as Stacey Abrams had done in Georgia, is expand the pool, get more people registered and voting, or sort of what Biden to some degree has done, which is to go after, sort of older white voters in the Midwest, et cetera. And so I think those are two tracks, is like, can you do both? But let's stay on track with some of the other questions. I want to get to audience questions. So one question says that Democrats spent 4 years challenging the legitimacy of the election on completely disproven charges. Republicans are likely to do the same on similarly disproven ground. What is the chance this trend will continue?
Well, I think the premise of that question is wrong. I mean, you can name a handful of Democrats that the first proposition in that question would apply to, but it's a tiny fraction. And in the Republican Party, the critical mass of the Republican Party, I mean, over 120 Republican members of the House voted against certifying the slates of electors from all of the states. The number of Democrats in the House who challenged Trump's election, you could count on one hand, and you don't need your thumb. So I just think it's a fundamentally wrong comparison. Now, if the question is whether there is some deep political divide between the parties that is unprecedented and that is going to doom the country, I think the answer to that is also no. I was in graduate school in history before I was in law school, and studying 19th century American political history, and you could have thought, living in the 19th century, even a generation before the Civil War and even a generation after the Civil War, that the country was just coming apart at the seams. So I think that there are very significant differences in the 21st century, and I do think that it's a mistake to say that just because we had similar problems in the 18th century, the 19th century, the 20th century, that there's nothing unique about the present moment. I think there is something unique about the present moment, and I think it's social media and the internet that didn't exist in most of the 20th century and any of the 19th century. And the existence of social media is much more effective at, number one, creating silos than any communication regime prior to social media was, and second, disseminating falsehoods. Mark Twain said, 150 years ago, a lie gets halfway around the world before the truth gets a chance to get out of bed and put its boots on. And the idea was that the truth never catches up with the lie. And that is true. But the number of people that consumed the lie in Twain's era was trivial compared to the number of people who consume the lie now. And I don't have any idea what the solution to that problem is. But I think that is a real problem that we face. And when Emily talks about the demise of democracy, I think that the prospect of that can't really be separated from the ability of falsehoods to circulate on social media in a way that was just not possible a generation ago.
And I would say coupled with that is you also have media deserts. There's just a decline in local media, whether it's news, print, TV, radio, et cetera. So, people are not consuming, as much and varied sources as they may have in the past. It's just not available to a lot of people. Next question. Professor Morales, I disagree with your assertion that the big lie led to the insurrection on January 6th. This attempted coup was planned. It was not spontaneous, as you suggest. It was multifaceted and due to, among many things, tradition and the rule of law that it failed. But our republic hung by the thread on that day.
I guess I don't know that I disagree with that. If I said it that way, I misspoke. I didn't mean to. What I was saying was that the big lie started after the election, and so what led to it was the proximate, relentless effort by any means necessary to overturn the election via those lies and the amplification of those lies. I agree. It seems like evidence is coming out about some planning related to it. And, I think we will get to the truth on that. So I certainly didn't mean to suggest it was spontaneous. So I hope I answered that question.
Great. Okay. And this is from one of our grads, former student, Rebecca Cohart. It's to Professor Berman, I think. Another question about the contract with the union. Is there any precedent for a prior administration entering into contracts that give it input over the policy to third parties? Have these types of agreements ever been litigated, or is this a novel problem arising after this administration?
Yeah, so that's a great question. I am not aware of it. I don't know that I know of any union contract that gives labor veto power over policies, but yeah, I'm not sure how much of an outlier this is. It is an outlier, and I think in part it's an outlier because you have a workforce that is so clearly and universally ideologically opposed to the incoming administration. So I don't know that you would have had that kind of adversarial relationship between an agency and the incoming administration to this degree, on this one area of policy. So the short answer is I don't know how much of an outlier it is. And I know the Biden administration is looking into ways to try to get out of it. And I think there are some provisions that give like a 30-day review period. So it may not stick. But I think it is illustrative of the sort of increased trend of outgoing administrations to leave their mark.
And you've seen some of this at the state level. I mean, in North Carolina, Wisconsin, among other things, where the change of administration from Republican to Democrats, some restrictive legislation was put in place to sort of restrict the incoming governor's power. So sort of interesting how this is being used sort of not only on the federal level, but also on the state level.
Right, but this goes further in the sense that it seems like it's a delegation of lawmaking power to a private entity of the sort that at least some people have been concerned about since Schechter Poultry. And then also the contracts professor in me is wondering about the doctrine of consideration, which I know is, sort of poo-pooed, but you can't, there are issues at least when one party just gives the other side rights under a contract without getting anything in exchange. And I haven't read this contract, and maybe they papered it over properly, and usually it's not too hard to fabricate consideration. But between the lack of consideration and what seems like, I have not read this contract, but it seems like an awful lot of delegated power over things that go beyond traditional work conditions to a union, strikes me as ripe for reversal through judicial action, I hope.
Well, not to mention the doctrine that contracts that violate public policy are unenforceable. And you don't have to spend very much time thinking about the million ways that the contracts like this violate public policy.
Next question. Given the many issues last fall regarding how and where to vote in the various states across the country, is there a 14th or 15th Amendment or other basis for Congress to establish boundaries, for instance, national standard on how voting must be carried out, independent of the otherwise restrictive language of Article 1 and Article 2? Any thoughts? Is there anything else we can do, I guess, to facilitate voting on a national level?
Well, Congress can use its spending powers. When you don't have an Article 1 enumerated power, bribe the states. So I think in some ways that's what a lot of people are trying to do over the summer, to include in some of these COVID relief packages a significant amount of money for the states to overhaul and modernize their voting systems. And so I think Congress could certainly entice states to do certain things through funding them, even if they can't do them constitutionally by mandate.
Right. Well, but I also think there is room for mandate. You've got 14th Amendment, Section 5, which gives enforcement power over things like equal protection. You've got the 15th Amendment, Section 2, which gives enforcement power over deprivations of voting rights based on race. You've got Article 1, Section 4, which lets Congress regulate at least congressional elections. And yes, the 14th Amendment has been, Section 5 has been, limited somewhat by cases like City of Bernie that my students love and discuss. But it does strike me that if Congress puts its mind to it and has the political will to do so, that there are things it can do to enhance fairness in elections.
And I do think that the voting rights are a big part of HR 1, the first bill, and an effort to reinvigorate the Voting Rights Act that was eviscerated by Shelby County. So yeah, certainly that kind of thing is on the table.
Next question. Actually, this one may be for Dr. Murray. It's not directed at Dr. Murray, but it says, any way to prevent the political center from being squeezed out?
Could you repeat that, please?
Is there any way to prevent the political center from being squeezed out?
I'm not a congressional political scientist. I think, as I understand the question, censure is always an option.
No, not censure, squeezed. So the center, not censure, center. Political center. I think he means the middle. I think what the person means is probably the middle of the electorate as opposed to left versus right.
Well, there are just a whole bunch of underlying factors. One is, let me mention, a change in law that was hardly noticed in the 80s, the end of the Fairness Doctrine, which almost directly led to the emergence of major outlets like talk radio and Rush Limbaugh and Fox News. one of the more perceptive people that look back at Nixon's impeachment and forced near impeachment. And if Fox News had existed, Nixon would probably have served out his term as president. So the whole media culture has changed. People could become very, very rich, particularly on the conservative side, a lesser degree on the liberal side, with this highly polarized media environment that is so prevalent, as we've seen in this 2020 crisis, that the Trump people aren't listening to anybody except people that, maybe that My Pillow guy went over the line, because fortunately the law does enable you to sue people. And so he was, being shut down, I saw last night, by Newsmax. But boy, unless you go way over the line, you can say damn near anything, more of it on the right than the left. But it's just a different world than existed. And then, with social media piling on top, and Section 230, where, you can write anything on the bathroom wall, and you're basically going to be, it's very difficult to rein that in. So it's quite depressing. I can't imagine we repealed the fairness doctrine, and probably Section 230 and the enormous power that the handful of media conglomerates have made so much money off our personal information. Yeah, that's probably something we'd be engaged with. But Rush and Fox and Rachel Maddow, they're embedded, and that's the world we live in.
Yeah, I mean, it does raise issues that, the media, fairness doctrine used to require the media to cover important issues and cover both sides of an issue. And now we're really relying on the journalist's integrity and sense of ethics to sort of do that. And that sort of has changed. Here's a question specifically for Professor.
Let me actually comment on that.
Okay.
I mean, one thing to note, when I was talking about imagined communities, one of the historical facets of imagining nation states has been the rise of newspapers and a literate populace. And so, I mean, newspapers are literally responsible for the rise of nationalism and sort of the modern era of nation states. And so we've always been reliant on our media environment in some sense to create a shared sense of identity. And now I think what Dr. Murray is pointing out in part is that because we don't have a shared media environment, we essentially live in two separate nations. We imagine two separate countries in our heads. And I think we're seeing how extremely dangerous that is.
And I think the challenge, of course, is that, one of the questions was about facts, right? What are the facts? How do we determine what the facts are of any particular situation? Because we may have political differences in terms of left, right, middle, but if we're not dealing from the same set of facts, then how do you really determine what the best course of policy would be? Is the challenge, right? Next question. Hold on, let's see. Mr. Professor Berman, I felt for years that executive orders have been used to exceed the constitutional power of the president by presence of both parties. Where does the power to use them originate? I thought the purpose of executive orders was to execute or enforce laws passed by Congress, but it seems to go far beyond that and often are used in a manner contrary to what the law is or intended to be. Is my impression of the purpose of executive orders correct? And if it is being used to bypass or reverse congressional action, how can it be corrected?
Yeah, so I think the questioner is right in that the basis of the power to issue executive orders is the president's the executive power, the power to execute the laws. I think that Congress delegates a lot of power to the executive branch, which results in an enormous amount of discretion regarding how the laws are going to be executed. So if you take DACA for an example, Congress hasn't specified how to prioritize deportations and they don't legislate the nitty-gritty details. Instead, they pass the framework immigration laws, and then because we as a country, we lack the resources to literally enforce every law that there is, the executive always is making choices about priorities. And so DACA was a systemic way of implementing a particular policy priority. Whether that's an appropriate use of the executive power or not is up for debate, and I don't pretend to know the right answer there. But I think in large part, it comes from the frustration that Professor Morales was talking about, where you campaign on a set of policies, and then you get into office and you realize you're not going to be able to deliver. And so you're not going to be able to implement the things you were sent there to do, which means you're not going to get reelected. And so the temptation then is to just use the levers of power that you do control to try to do as much as you can. So in some ways, I think it's just another symptom of this polarization and division and gridlock. And the Supreme Court has started making some noise about this. I think it's possible that there will be some limits placed on the amount of delegation of power that Congress is allowed to give. The non-delegation doctrine will live again in some form, I think. And so that's one sort of solution to the degree that you're looking for solutions. But really, again, I think the way I think of it is more of a symptom.
Yeah, I agree with Professor Berman. I mean, I think one thing to think, you can't understand executive authority without understanding congressional sclerosis and the inability. I mean, it's not just partisanship, right? It's a bunch of structural things that have changed in the way Congress works related to partisanship. Earmarks and pork, which, everyone maligns, were actually how anything got done in prior Congresses, and they encourage people to go across the aisle and scratch each other's backs. And so I think what was a well-intentioned reform at the time, to sort of say, well, we shouldn't have bridges to nowhere, and, there shouldn't be all these special projects. That's not a good way to make policy. I think we've seen that it's really dramatically cut the amount of deal making that Congress can do. I mean, look, Congress goes into budget crisis every time it tries to pass a budget. I mean, our Congress doesn't work, it's not functional. And I know that I'm like the doomsayer on this talk, and I do appreciate my elders like Professor Dow saying it will be okay, because I don't think that's wrong. I mean, I think we've seen the system respond in this last election cycle, but I do think that we're on a path where it's really hard for government to do the business of the people in any form. And, I think that's why we see the executive power kind of rising up to try and compensate, even if it's not traditional.
Dean, even before Professor Morales called me an elder, I wanted to say something about his observation, and that is that I think that it's obviously correct to say that Congress is dysfunctional. I think that's obviously correct, and I think Professor Morales has pointed to one of many reasons, or several of many reasons why that is true. But I think that there are a couple of other points. And one is that there continues to be a divide that has existed in the United States since the late 18th century, and that we still haven't figured out as to how much the federal government should do versus how much the state government should do. And it's true that the Civil War amendments really altered that balance, but it's still a debate. And so if you have a significant number of people in Congress saying federal government shouldn't be doing this, the states should be doing it, then that's part of the recipe for stasis. And the second is simply that that governing, like all other areas of human knowledge, has become increasingly specialized. There's not a single member of Congress who could talk intelligently about more than 3 things that the federal government does, and the federal government does scores of things. And that was not true in the 18th century, and that was not true in the 19th century, and that wasn't even true in the first half of the 20th century. And so we now have a government that's basically run by administrative agencies because those are the experts, and the smart members of Congress realize that they're not the experts that the administrative agencies are. And so they just want to, keep handing it off. And Professor Berman might be right that the non-delegation doctrine is going to come back. And if it comes back, then I'm going to be squarely in Professor Morales's camp that the wheels have completely come off and everything is just going to crash and burn, because then we're going to have a bunch of people who don't know anything who are going to be all of a sudden in charge of running things again.
And the challenge, though, between now and earlier times that you mentioned, Professor Dow, is that we are a superpower with one of the largest economies in the world, and so to even have some dysfunction, or how even if it's limited, it does put us in a big disadvantage where we're maybe our infrastructure is failing, and school system's not as good as it could be. There's a lot of things that are not happening because the parties and the government can't get itself together to address really the hard questions that exist. And that, and that I think is a challenge for us as we go forward. So I'm not quite in Professor Morales's camp, but I do think that we have to recognize we are in a very difficult situation as we move forward. Next question. I have a question about the president's power as commander-in-chief and requirements to defeat insurrections. I worry that the president could allow supporters of theirs to be violent by hampering the military from acting against them, as was done on January 6th, is what the questioner says. If an insurrection exists, is there any requirement for the president to stop it? Since Congress has given power to the president under the Insurrection Act to defeat rebellion, could the president support rebels by refraining from defeating them? Any thoughts?
Yeah, so I guess I'll chime in here with my national security hat on. So the president has a duty to defend the country. It's part of the oath of office that he takes, and the Supreme Court has said that means that when the country is attacked, the president has not only the authority but the duty to respond. So in theory, the obligation is there. Now, how vigorously the president executes that responsibility can vary in the way that, the vigorousness with which he executes any law can vary. So I think one of the things that I would like to know much more about January 6th is exactly what was the president doing? Who was he talking to? What did he know about who was and was not authorized to call in the National Guard? Who was making those decisions? Was he discouraging people from making those decisions? I think those are all important questions to get to the bottom of. But I mean, certainly as commander-in-chief, the president has a lot of authority and could do great damage in a situation like that by acts of omission. At the same time, our military has a really great culture of law following, and they know that they are not obligated to carry out unlawful orders. And so I think that I was less worried that the military in some way would be roped into these shenanigans. And in fact, we saw it really actively trying to distance itself from the conflict in the days leading up, maybe to a fault, maybe to a degree that resulted in delay. But I think that there they also take an oath to the Constitution and not to the president. And so, fortunately, unlike Myanmar, I don't think we have to worry so much about military takeovers, regardless of what the president does.
Yeah, and I'd point out that the military is, I mean, if there's any institution that's, now the military has its problems like all of our institutions, but I think the military probably has held up, kind of acquitted itself overall better than most institutions. And I think, my father was a veteran in the Air Force, and I know just from his experience and the experience of other veterans that the military has done a sort of excellent job of integrating the force. I mean, in other words, the military's vision for America is a multiracial vision. And I think that's a really, really good thing, even though we've had, there's been reports of military officers involved in the invasion and everything else. But I actually do have quite a bit of confidence that that's going to get worked out within the force and in the Pentagon. But, maybe that's where I'm too overconfident, but I think that's a really good sign for the future, actually, is the professionalism of the military and its commitment to sort of diversity and kind of living out its constitutional oaths.
Anyone else? Okay, let's move on to this question. From the small amount of research that I've done, not one court has actually allowed evidence to be heard regarding the allegations of election fraud in the 2020 presidential election. Am I wrong in believing this? Does anyone know of a court that has considered the case's evidence before dismissing the case? As far as I can tell, many of, or even all of them, were dismissed due to reasons of justiciability.
Seth, you're muted.
All right, so the questioner is wrong. There were courts that did hear or provided an opportunity to hear evidence. I don't have a number for you as to how many there were, and certainly there were a lot of justiciability problems. But there were courts that heard evidence, and it simply did not materialize. So I think it's inaccurate to say that we have. There may be more evidence out there, who knows what will come in. But given the opportunity to present evidence, these fanciful affidavits that were supposed to be present either didn't materialize, couldn't be substantiated, or didn't prove very much. And so I think it is fair to say at this point that there is not a lot of substantial evidence that there was significant fraud in the election in a fashion that would have changed the results. And I will say there was a huge motivation, a very well financed motivation, to find and present that evidence. And so, when you have massive opportunity and massive dollars behind you and nothing turns up, that's a good suggestion that it's not there.
You mean that the fact that Dan Patrick has not had to pay out $1 of the $2 million he offered as a bounty? Perhaps nobody needs money, but more likely nobody's got anything that will enable them to, show something that a court might respect.
Any other thoughts?
Yeah, I think it's really important to emphasize this point. I feel like I've never been more aware of our sort of platform here to kind of dispel untruths. But I think I want to try and account for the cases that quote unquote like didn't hear evidence. To the extent, right, it's the lawyer's duty to present, right, credible evidence supporting or allegations, but ultimately evidence, and all of these cases went forward on an expedited basis. So when the courts that dismissed without evidence, that's because when a court gets a filing, and I teach civil procedure and I teach my students this, when a court gets a filing, a complaint, which all of these cases started as complaints, the court is bound to believe every single thing in that complaint is true. So these cases where evidence wasn't presented, it was presented. It was presented in the complaint. And the court nonetheless said, even if everything you said is true, you would not win. Either because, as Professor Chandler correctly said, all of these complaints were full of small bore allegations that didn't amount, even if they were right that the votes were fraudulent, they were talking about 10 or 20 votes in elections that were won by hundreds of thousands. So I can't say that enough. And I want to be very clear that they did get a chance. Every single case gets a chance to present evidence, because every case, the judge has an obligation to believe every single allegation before dismissal.
Let me start, if I could, just in case I did find a case while we were online, which is the Third Circuit's opinion in a case called Donald Trump for President versus Secretary Commonwealth of Pennsylvania. The author of the opinion is a Trump appointee, Judge Bibas. Here's his opening sentence. Free, fair elections are the lifeblood of our democracy. Charges of unfairness are serious, but calling an election unfair does not make it so. Charges require specific allegations and then proof. We have neither here. And I think that is, there were a number of decisions that are similar. Yes, there are those that were dismissed on grounds of justiciability, but there are cases that looked at the evidence, and as Judge Bibas says, it's just not there.
Last point on this, and I'll be quiet. I was a poll watcher in Wisconsin for the Democratic Party. 500 people, or no, 1,000 people voted on election day in our precinct. There were 4 lawyers in the room the entire time monitoring the polls. That's how much, right? There were 2 Republican lawyers in there the whole time and 2 Democratic lawyers. And I just can't stress enough how much attention was paid to every single vote in any state that mattered. And that's what just makes me incredulous about this fraud claim, because you had so much observation. So I'll stop there.
Next question is for Professor Morales directly. I'm concerned that Biden has a harder sociology problem than LBJ in '64. In that LBJ had a large electoral mandate and a moral mandate to pass civil and voting rights legislation, while Biden campaigned on eliminating systemic racism. It did not get a comparable electoral mandate. Could you comment?
I don't disagree with that statement. I think it's going to be very hard for Biden to make the kind of systemic change that the people who elected him to go in there and do to achieve. I absolutely agree. And part of the reason, right? I mean, part of it was the civil rights movement and the particular moment in history where LBJ was able to do those things. It also, though, was a period where the Democratic Party itself was split, right? And so you had progressive Republicans on racial issues and Southern Democrats on race issues. But they could agree on some things, especially when it came to social welfare programs, right? And so partly what's happened too, it's this realignment where the parties are completely split based on ideology. And so that was another advantage that LBJ had, but I think the observation is extremely apt, and I agree with it.
Another question. I hope this group isn't looking forward to a one-party system in the United States. It's hard to tell from your collective remarks. Do any of you have a desire to see the Republican Party survive and even thrive alongside the Democratic Party?
I absolutely.
I'll answer that one. As probably the most, I'm surely the most conservative member on this panel, which is, if the Republican Party wants to survive, it needs to be focusing on issues and, I would say, traditional Republican values, rather than becoming a mouthpiece for Donald Trump, whose values I do not think are traditional Republican, but are much more idiosyncratic. And so I mean, speaking personally, I do have concerns about the left wing of the Democratic Party getting great control. There are many things that they're doing that I do not agree with, that I do not like, that I don't support. And so I would welcome a sensible Republican alternative to keep that in check. What I am concerned about, though, is that you see at least a significant minority, if not a majority, of the Republican Party siding with the fantasy world of Trump supporters, as well as policies that, some policies at least, which I think are at least as indefensible as those of the radical left on the Democratic side. And so I do think it is important, very important, that we have a serious debate about values, about the national debt, about foreign policy, et cetera. And that does need a responsible opposition. But in my view, if it's going to be, if you're going to have serious opposition, it needs to be based on principle, on fact, on science, on respect for people. And my fear is that the Republican Party has become essentially a cult that is going to prevent it from becoming a serious opposition party. And that does empower people in the Democratic Party that I personally would prefer not have a lot of power.
I'm on the opposite end. I'm probably the leftist wing person here, or about, but I too share Professor Chandler's view. It's essential that we have a functional conservative party that believes in democracy, and respects norms of voting and control. And that's because I'm also a pluralist. I think everybody has the right to make up their own views and decide based on facts and their own values. And without a conservative movement that does that, I think that's a huge danger to democracy. So I absolutely want a functioning Republican Party, but I share Professor Chandler's concerns extremely that a functioning Republican Party can't be one that doesn't agree on, doesn't join us in reality. Fact-based reality.
I think especially so I agree. I would be happy to see the left wing of the Democratic Party have a lot of power, but despite that, I still think it's quite important to have a loyal opposition, as it were. And to me, what that means is a Republican Party that buys into the rules of democracy. And so you can't have an opposition party whose position is, if we lost, it's because the election is rigged and the other side doesn't deserve power and they are illegitimate. We all have to buy into this, to the idea of democracy, that you have elections and some people win and some people lose and the losers try to win next time. Meanwhile, the winners get to govern. And right now, I feel as if the Republican Party, or at least the loudest voices in it, have rejected democracy. And that is not a viable way. One party system is not a viable way for a democracy to operate, but a two-party system where one party doesn't believe in democracy is also not a viable way for democracy to thrive.
I'll do two more questions and we'll break. I know we're going a little bit over, but it's been a very scintillating conversation and I want to make sure everybody's heard. So one last question, two last questions, next to last question. With all due respect, hosts of folks are getting thrown off Facebook, Twitter, YouTube, et cetera, if they say the wrong thing. Biden is proposing a realist czar akin to 1984 who will determine what the truth is. Any comments or thoughts on that?
Well, it's interesting to me that the proponents of a broader notion of state action are coming from the right, which has usually favored a narrow notion of state action. It is true that the social media giants do have a considerable amount of power, but there, you saw a remedy, which is that you can get together a competing service pretty quickly. And if those competing services don't themselves foment violence, then they can do as they please and people can join them for better or worse. So while I don't think it's wrong to be concerned about agglomerations of corporate power suppressing speech, I also am not convinced. I have not seen the evidence that Facebook, Twitter, etc., are exercising that power in a particularly in a widespread irresponsible manner. There may be instances when they've gone overboard, but I'm not aware that they've done it broadly. And so as far as establishing, I don't know what the reference is to a truth commission or whatever, and I certainly would not like to see the government serving as an arbiter of what is true or false. That is a nightmarish way to go, in my opinion, but I'm not aware that they're doing that.
Any other thoughts? Okay. Last question, and it was directed to Dr. Murray specifically. They want to know whether the questioner want to know if they thought the Republican Party was going to divide in two.
The Republican Party is.
Would it divide in two, split? I mean, so Lindsey Graham, for instance, he's been quoted saying, that we, in essence, that, this is going to tear the Republican Party apart. I think is what paraphrasing what he said, sort of these circumstances.
I think short term, there's a pretty high likelihood for an election cycle, or possibly through the presidential in 2024, that might happen. It sort of happened back in 1910 and 11 and 12, when Theodore Roosevelt came back and was deeply disappointed in Howard Taft, and they ended up running. But the result of that, of course, was a disaster. Mm-hmm. The American electoral rules severely punish a divided party. And people that may have a lot of passion and think that the majority's on their side are sort of sobered up when you get crushed in an election. So I think one way or the other, it's really hard to start a new brand. So I think the question is within the Republican Party, how this shakes out. And it may take an election or two. But I think the Republican Party will come back, and you lose elections, you usually try to figure out why in the hell you've lost. May take a while. I think there's some analogy between the British Labour Party in Britain in the 1930s, where the Trotskyite wing was the tail wagging the dog and made the damn party just about unelectable for a decade. And the Republican Party is in danger of that. The Democratic Party has lots of problems. It's ever since Jackson, it's a coalitional party. Every, great line about the Democrats in the 1880s is it's the party of rum, Romanism, and rebellion. It's the disgruntled Southerners and the Catholics and the wets. I'll drink to that. So and it still is. You got all these, the Muslims are in the party. The Jews, it's an extraordinary balancing act. It's very hard to hold together. Trump's provided glue in the short term, but not that they don't have their problems, but the Republican Party has an existential crisis. They have had a demagogue of gigantic Greek proportions emerge that sensed this vein that was so important and exploited it, and it's their problem. And I don't know how they're going to deal with it. It won't happen quickly. Even if Trump were to drop dead, the Trump kids are probably prepared to pick up the torch and charge forward. Both parties have unique and very different challenges. But the Republican challenge is an existential one. Do they fundamentally believe in democracy? And if they don't, I don't see a great future for the next election cycle or two.
Well, on that note, let's conclude this great presentation by our experts, and many thanks to Dr. Murray, to Professor Morales, Professor Berman, Professor Chandler, Professor Dow, and for all the audience members who hung in there. I know we went a little bit over, but I wanted to address all the questions that you had. I think we've done just about all of them. So many thanks for this very important conversation about this particular and very unique presidential transition of power. And the Law Center is here to have again, these very difficult and complex conversations. We're going to continue to have them. And for those who may be seeking out CLE, I know that there'll be a PowerPoint with the QR code. If you did not get a chance to see that in the beginning, it will be posted now after we conclude. So again, many thanks to the panelists, many thanks to Associate Dean Tennessee and Hope Young and many in our Alumni Affairs Office. Many thanks to all of you for attending. So have a good evening. Thank you.